Today we are going to discuss about the thing that what are the loopholes in matrimonial legal system. Actually, if it is considered in India, on the perspective of India, I think that Indian legal system is not at all a foolproof, especially in case of matrimonial system. You know that after the breakdown of our patriarchal society, the new society is going to develop. In matrimonial laws, the living in relationship is not acceptable. After the judgment of Honorable Supreme Court, it is clearly said that the matrimonial laws uh, that in each and every spouse may have relationship with the others. So if that is be the so, then living. But the problem is that in matrimonial legal system, that presently is the adultery is just a ground for divorce. It is not at all punishable in India. Here the problem comes after the judgment of Honorable Supreme. So if there is any adulterous relationship in of husband and wife with the other, then you can pray divorce. But in present situation, present some cases, we have seen that that all the marriage functions are doing going on between the husband and wife. After the matrimonial function, they have been relationship. They have lived in their relationship as a husband and wife. But after some time, they said that they are not married. So the question of divorce does not arise. My question is here. Today I want to discuss the loopholes. What are the loopholes in Indian legal system? So first I come to Hindu Marriage Act. You know very well the Hindu Marriage Act is applicable only for the adult Hindus. Both the spouse, that is husband and wife, must be the Hindu. And in case of Muslim marriage system, then there is a nikanama. You know very well that in that particular system, that both the husband wife must be a Muslim. So another matrimonial law is also prevailed in India, that is Special Marriage Act 1954. So in that particular act, there is no religious bar. The husband and wife may be the maybe Hindu or Muslim, and any religion they can be married to each other. Now the question is here: if it is Hindu Marriage Act, when the spouse or the husband and wife perform Saptabodhi, then the marriage has been completed. That is the seventh step of the seventh step of the in front of the sacred fire. You know that is called Saptabodhi. So when the Saptabodhi has been performed, that is the seventh step has been performed, then the marriage is completed. Though there is a registration part, I will discuss it later. But the marriage has been completed. So if the spouse are Hindus, they can complete the marriage by performing Saptabodhi. And after that, they can register their marriage. And presently, there are so many judgments where it is said that the marriage registration is compulsory right now. But in case of special marriage, the clause is here. The special marriage is completed when the registration has been completed. So none of the above marriage has accept the living in relationship as a marriage. So when now the question, the problem is that when one of the spouse is a Muslim or any other religion and the another person is a another religion, they can marriage as per the Special Marriage Act. But the Act says so that the marriage has been completed when there is a registration. But in present system, the present situation, you know very well that husband and wife has that the adult girls and boys and are performing the marriage ceremony and said they are married, and if they are Hindu or Muslim, then they have not registered the marriage as per the Special Marriage Act. And now the question arises, when the matrimonial ceremony has been performed, they declared themselves as a husband and wife in front of the society. Then after some time they are saying that they are not married. So the question is here, the law says when the registration part has not been completed, they are not been treated as a married. So here they have not completed the registration part. So now they say that I am in living in relationship, I am not married, I am not registered, that this is not at all a marriage. So here the loopholes is, if during this relationship there is a if during this relationship there is a mm, pregnancy or this type of things are going on, then who is the father or mother? The biological father is there, but that has not been accepted in the society because they are not married. Now the question is, this type of problem is very serious. Our Indian system never accept the living in relationship, and even after the Supreme Court judgment that the adultery is presently is almost a ground for divorce. But if there is no question, if there is no penal provision, if there is no legal framework, if there is a living in relationship, now the problem has started. There is no legal framework regarding the living in relationship. So, in case of living in relation, there is no law at all. So now this is the biggest loopholes of our matrimonial law. I am not giving any blame to our the lawmakers, because when this law has been framed, that is in the Hindu Marriage Act has been framed in the year 1955, and Special Marriage Act has been framed in the year 1954. In that system, in that time, there is no question of living in relationship at all, or it is very much less. But in present system, present society, they are accept. If we accept the adultery as no offense, if then we have to accept the living in relationship, and definitely there must be a legal framework. I think that there are so many judgments in different high courts, but that judgment is not at all so strong legal, so strong from the side of legal, that they can act as like as law. So now this loopholes is quite clear. When there is an epidemic, there is anything, then maybe when they declare themselves as a husband and wife in front of the society, then they they are comes under the purview of living in relationship. And I think that the marriage, if the living in relationship is not accepted, or if it is not possible to enact any law presently, I think that in matrimonial law there must be a definition of marriage. There must be a definition. Previously I think that there is not required at all, but I think that should be amended at all. There must be a definition of marriage. It is not only sacrosanct. Presently, marriage is still being a sacrosanct in our society, but living in relationship is not sacrosanct. So I think there must be a good framework, legal framework on this point. In present global village, our culture, our system has been changed. The municipal laws, that is the laws which is in our society, is almost changed due to this type of globalization of our culture. I think that this should be, there should be strong legal framework on this point. Now, another question I think that is it must it is very I'm willing to discuss, and it's very relevant at all. But in our previous legal system, I think that that the law is almost gender based. The law is always not gender neutral at all. But I think that not only in case of matrimonial laws, but also in criminal laws, that is the in question of rape, in question of sexual intercourse, the system should be changed. We are only considered that the rape can be done only on the girl at all or a woman at all. But in present system, I know very well, being a self-employed advocate and as a student of legal fraternity and as a research work on the legal fraternity, I think that it must also be changed. But because if the rape is perpetrated only on the woman, the same can be perpetrated on the men also. Although that number is not so many increasing right now, but I think that it will be increase in the next few decades. So there must be a legal framework on this point. I am not saying that present legal system is good or bad. That is not my point. But my point that this system should be changed after considering it as a global cultural system. It is very important. When our culture has been come to a global system, then definitely there's definition of rape, definition of unusual sexual intercourse or this type of thing, but forceful sexual intercourse, it must be changed. So for if we think that rape is is a criminal act from the part of the men, definitely the in present system I think that it should be equally punishable for the women also. That is very much general neutral should be there. Previously, when it is the criminal law has been enacted in 1864, you know that the British person who has enacted that particular law, then at that time this thing has not happened, but presently it has regularly happened in our society. And definitely, as because there is no legal framework, all the culprits has been uh, go out from there. They must be penalized, and if that cannot be do so, then definitely the society, there must be a problem in the society. Now I think that it must be a very important thing which we are going to discuss today, that the gender neutrality laws. You know very well that in case of 125, if wife or father and the mother of a person is not capable to maintain themselves, they can come under the purview of um, section 125. But if the same thing in present society, these are also been happening, that if the wife is in higher post, why not the husband can claim maintenance from her? What is the problem? I think that this should be also gender neutralized. This should be. Definitely, there may be so many comments, there may be so many criticism may come from the society on regarding my comments, but I think that it should be changed. It should be changed. You know very well that if there is any torture upon the woman, I hate that torture, but still there are so many torture upon the men also. We are not considered that torture as a torture at all. So I think that this should be gender neutralized. Now, the again I go to the loopholes of this type of system. Okay, why these things are necessary today? Because after global neutralization or global gender neutralization, all things can be possible. When we make the law is definitely be made, should be the changing needs of the society. Law is regularly be made to meet the changing needs of the society, to go to the correct direction of the society. If that can be do so, definitely this type of law should be changed. And upon this, I think that all our advocates, all the social publics, all the lawmakers should think from the next few days that they will change it. Now, if it is possible, then I can produce some data. Definitely, please go to the data of NCRB, National Crime Records Bureau. That in almost all cases, you know very well, all 490 cases, all 490 cases, only few person will be penalized. That means only in a case of 100%, in 100 cases, only 3 to 4% is penalized for the 490 torture 490. So if that for these 3%, there must be a law. Definitely, I think that if the torture is from the woman's side, then definitely another law is there. Is requirement of law is there, and law is not there. Then the requirement of law is there. So you you must think about so. The lawmaker should think about so. Don't consider that all the things are in the pressure of the society will consider things. So now it is very important and it's very useful for these declarations. And I make this video for the gender neutrality law. Today I think that we should raise our voice that the law should be gender neutral. Uh, any criminal act is done, even it is done by any gender, that should be penalized. It is gender neutralized law. I raise my voice. That is the social justice. In Rajesh versus Neha, what Supreme Court has done? Why Supreme Court has direct to file this type of affidavits, the formats of affidavit which are regularly going to file each and every case in India? The only cause is this. The Supreme Court considered that in the from the side of white there is no such framework. I think that is very important. Thank you, and we will our next video with some other points we will be discussed later on. Thank you very much for watching this video. Thank you.